I'm Tiffany Weber. I'm a real estate attorney in Mooresville, North Carolina at Thomas & Weber. In today's video, I'm going to be breaking down the changes to the July 2022 standard offer to purchase and contract for North Carolina real estate. Let's dive into what necessitated the changes for this July and how they're going to affect your transaction. All right, so the first change to the contract appears on page 1 in paragraph 1C. This identifies the property, and now there's a checkbox for you to select whether or not there is a manufactured or mobile home included with the property. And if so, then now there is an instruction to make sure that you use the additional provisions addendum and include the mobile home provision in that addendum. Otherwise, your contract won't quite be complete. Next, the breakdown of the purchase price in paragraph 1D sees some minor changes. The first change is with the initial earnest money deposit, and before the contract said either the initial earnest money deposit was attached with the offer or it would be delivered to the escrow agent within 5 days. Now it just says that the earnest money deposit will be delivered within 5 days. Also, the additional earnest money deposit now adds the checkboxes to determine how the deposit will be delivered, so whether by cash, check, etc., and also says that it will be made payable and delivered to the escrow agent within 5 days. Before it just said made payable to. Also, the list of fixtures has changed. So inflatable pools, spas, and hot tubs are now excluded from the list of fixtures. Fuel tanks are now omitted from this list as well, but that's because they have their own new section. Next, section 4D talks about repairs and improvements. There's a minor change to the language in the second bullet point, but it doesn't really change the effect from the prior contract. As always, negotiation for repairs is optional. However, there is a more substantial change at the end of this paragraph that says if repairs are negotiated and agreed upon, then that agreement has to be in writing and signed by both parties. Then it becomes an addition to the contract. Moving on to paragraphs 5D and 5E, these both get the same update, and they deal with certain disclosures that have to be made to the buyer from the seller. So the Residential and Property Owners Association disclosure, and then the mineral and oil and gas rights disclosures. Before, there's a box that said that the buyer had received these documents, and now there's language that says the buyer is also acknowledging compliance with a certain statute, which is called the Residential Property Disclosures Act. And it's really important now that you don't check the box that you've received the documents if you haven't actually received the documents. So pay attention when you're checking those boxes. Now comes the new section on fuel tanks. Agents should read this section very carefully, and if there's a fuel tank located on the property, then all sorts of information is going to have to be disclosed, like the type of fuel, who is the vendor that services the fuel tank, where is it located. And my guess is that there were a lot of disputes over the past year about whether the fuel tank was included with the sale of the property or not. So now that is no longer going to be unclear. The rest of the seller's obligations in paragraph 8 have remained mostly unchanged with 2 small exceptions. HOA issues have their own separate paragraph now, so anything that was included in paragraph 8 about HOA has been moved to the new section. And the opposite happened with home warranties. Home warranties used to have their own paragraph, and now they're just included in this paragraph 8 under seller's obligations. All right, now everyone's favorite topic, HOAs, that's a new paragraph 9. This section now more specifically identifies that if there is an expedite fee charged by an HOA management company in order to get the transfer information, then the seller is obligated to pay it. And also, this paragraph talks about the things that the buyer is obligated to pay for from the HOA management company. The short answer on this is that if something is not specifically listed as a buyer expense, then the seller has to pay for it. There is a new line item added to the seller's portion that says any item that was not specifically enumerated under the buyer's section. So that's a really easy way to look at it. You get a charge. Is it on the buyer's list? No. Okay, seller has to pay. The paragraph that deals with the condition of the property at settlement saw some minor changes as well. Minor in words, but important in outcome. And this allows, if the property is not in the same or better condition at the time of closing than it was at the time of the offer, then the buyer can not only seek return of their earnest money, but their due diligence fee. And finally, the remedies paragraph in paragraph 23 makes it more clear that the buyer has the option in the instance of seller breach to pursue specific performance as a remedy. Now, this is not really a change because the buyer already had this right. It's an equitable remedy allowed by law, but now the contract specifically says it just to eliminate any confusion between the parties as to whether that is an option that the buyer can pursue. So there you have it. Those are the changes from the July 2021 version of the contract to the July 2022 version of the contract. It became effective on July 1st. Our office in the middle of July is still getting versions of the old contract, so make sure you switch over. You can find it at the North Carolina Association of Realtors. They have a whole form repository. Your agency probably has these updated forms, so make sure when you're going under contract you're using the most up-to-date version. All right, I'm Tiffany Weber. I'll see you in the next video. Make sure you comment and let me know which change you think is the most important.